All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Before we start and pursuant to my decision setting the date for this first appearance, the court photographer is permitted to take a few photos for 1.5 minutes. Please proceed. Sorry, can you activate your microphone?
Your Honour, thank you.
Thank you.
Can I raise one short matter to do with the photographs? There's no objection to the photographs taking place, but I do question the need for the officers to be in court surrounding Mr. Gucati in these circumstances, bearing in mind the matters for which he appears before Your Honour, which are matters of obstruction, but not substantive offences under the jurisdiction of this court. And I do question whether it is necessary for photographs to take place with officers surrounding Mr. Gucati, or indeed why officers in what is obviously a secure courtroom are necessary in court in the first place.
Counsel, would it be satisfying for you if there were a picture of your client without the security guard around him?
Yes, I would certainly invite that to take place. There's no objection on his part to the photograph taking place, but I raise a concern on his behalf of the necessity for a police officer to be sat around him, firstly when that photograph takes place, and indeed during the course of the hearing.
I mean, for the first part of your request, we can totally ask, I will order the photographer not to take any picture of your client with the security guards around, so I think that can solve your first concern. For the second concern, I think it's a common practice in every courtroom, in all the international tribunals, and even a lot of domestic tribunals, that when you have a suspect or accused who is currently in detention, he or she is escorted by security guards who most of the time stay around him. So I don't see especially the need not to follow this practice, but I can ask Madam Prosecutor if she has anything to say on it. Madam Prosecutor.
Thank you, Your Honor. The prosecution is also in favor of confirming the established practice of maintaining security in the courtroom while the arrested suspect is present.
Thank you, Madam Prosecutor. Sorry, do you want to reply, Counsel?
Well, no, it's a short point, Your Honour, and I've made it. And I'm grateful for Your Honour's ruling in relation to the photographs. For today's hearing, I won't press the point any further, but it may be in due course I make some further submissions once I've looked further into the matter for another occasion.
Duly noted. So, Madam Photographer, I instruct you to make pictures of the suspect only at closed range, which means without any security officer around. You can proceed. Thank you. Thank you very much, Madam Photographer. You may now leave the courtroom. Madam Court Officer, can you please call the case, please?
Thank you, Your Honor. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hysni Gucati and Nassim Haradinaj. Thank you.
Thank you very much, Madam Court Officer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules that must be observed at all times in order to make the proceedings smooth. So please, make sure you activate your microphone before speaking and you switch it off as soon as you finish. Talk slowly and clearly, as we have interpretation into and from Albanian and Serbian. Wait 5 seconds before responding to me or a party or participant in order to allow the interpreters to finish the interpretation. What is said in this hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public after this hearing. I would also like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. Confidential information shall not be disclosed in open session. If any party or participant must go into private session and refer to any confidential information, please indicate the reasons. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Thank you, Your Honor. For the Specialist Prosecutor's Office are present Mr. Jack Smith, Specialist Prosecutor, Mr. Alex Whiting, Deputy Specialist Prosecutor, Mr. James Patz, Associate Prosecutor, Ms. Line Pedersen, Case and Evidence Manager, and I am Valeria Bolici, Prosecutor with the Specialist Prosecutor's Office.
Thank you very much, Madam Prosecutor. Counsel, if you can introduce the defense, please.
My name is Jonathan Elliston-Rees, Queen's Counsel. I am Specialist Counsel for Mr. Gucati. I'm assisted by Specialist Co-Counsel for Mr. Gucati, Mr. Valon Hassani, and a team member, Mr. Hugh Bowden.
Thank you very much, Counsel. And your client, Mr. Gucati, is also present in the courtroom for the record.
He is, for the record.
Thank you very much. Now I turn to the Registry. Madam Registrar, please.
Thank you, Your Honour. Fidel Madonlin, Registrar.
Thank you, Madam Registrar. And for the record, I am Nicholas Guillou, single judge for this case. The suspect is appearing today for the first time before the specialist chambers, following his arrest and transfer. I note that Mr. Gucati's counsel said that he could not be present at first appearance before today. I took this concern into consideration upon issuance of my scheduling order of 29 September 2020. I now wish to address the suspect. Mr. Gucati, will you please rise? Yeah, you can put on the microphone like this, on the button on the right. Exactly. Could you please tell us your full name, please?
My name is Hysni Gucati. of March 1967 in the village of Morin, Skenderaj municipality.
Citizenship?
I'm a citizen of Kosovo. I'm a secretary in the elementary school, Ahmet Deliyay, and at the same time, head of the War Veterans Organization of the Kosovo Liberation Army.
Any further, I would like to ask you to make sure that you can follow the proceeding in a language that you understand and speak. Can you confirm that you understand and speak Albanian?
Yes, I speak and understand the Albanian language.
By this, I am satisfied that you can follow the proceedings in Albanian, a language that you understand and speak in accordance with Article 41. If at any moment in the course of proceedings you are not receiving interpretation, please draw my attention to it immediately.
Thank you.
You may be seated. Let me now move to the procedural history of the case. On 24 September 2020, I issued an arrest warrant against the suspect in my capacity as single judge, having found grounded suspicion that Mr. Gucati is criminally responsible for the following offenses: intimidation during criminal proceedings, pursuant to Article 387 of the Kosovo Criminal Code; retaliation, pursuant to Article 388 of the Kosovo Criminal Code; and violation of the secrecy of proceedings, pursuant to Article 392 of the Kosovo Criminal Code. The specialist chambers have jurisdiction to prosecute these offenses by virtue of Article 15 of the law on the specialist chambers. The suspect was arrested in Kosovo on 25 September 2020, at which point he was served with the arrest warrant and informed of his rights. He was transferred to the detention facilities of the Kosovo specialist chambers in The Hague on the same day. I take this opportunity to note that there have been a number of new filings in the case file. Mr. Gucati, I have before me 4 requests challenging various aspects of your arrest and detention. With respect to these requests, I instruct the Specialist Prosecutor Office to file a consolidated response by Friday, 9 October.
Duly noted.
Thank you. And Mr. Rees, as you may have seen, I also issued 2 orders yesterday: an order on reclassification of filings and an order on the working language of the proceedings. With regard to the order on reclassification, I have already noted my intention to reclassify documents in the case file as soon as possible, so the defense can have access to all filings relevant to the arrest and detention of Mr. Gucati. The Specialist Prosecutor's Office and the Registry have been given until 14 October at the latest to respond. Now, allow me to explain the specific purpose of this first appearance for the benefit of the suspect and those joining us in the public gallery and following the proceedings online. Today's hearing is not a trial. The suspect has not been charged yet, in the sense that no indictment has been yet submitted by the specialist prosecutor. No evidence will be presented or debated, and the guilt or innocence of the suspect will not be discussed or decided. The purpose of this first appearance is regulated by Article 41 of the law and Rule 55 of the rules. According to these provisions, as single judge, I shall ascertain whether the suspect has been informed of the reasons for his arrest, namely the offenses allegedly committed, and the reasons for keeping the suspect in detention, and whether the suspect has been informed of his rights under the law and the rules, including his right to legal assistance. I expect the parties to limit their submissions to these matters, which I will address in turn. Should either party wish to discuss any other matter not expressly foreseen in the context of the first appearance, they are invited to do so in writing by making a filing before me. First, may I ask you, Mr. Gucati, to confirm that you have received the arrest warrant dated 24 September 2020 in a language that you understand and speak?
The arrest warrant was handed over to me on the day of the arrest.
Mr. Gucati, I will now ask the court officer to read the reasons for Mr. Gucciati's arrest as indicated in the arrest warrant. Please proceed.
Thank you, Your Honor. According to the arrest warrant, first, there is a grounded suspicion that Mr. Gucati is criminally responsible for attempting to commit the offense of intimidation during criminal proceedings pursuant to Article 387 of the Kosovo Criminal Code. Specifically, there is a grounded suspicion that Mr. Gucati held 3 press conferences on 7, 16, and 22 September 2020, where he distributed or otherwise made available to the media confidential and non-public information and documents relating to the work of the Specialist Prosecutor's Office, and made no interventions when Nasim Haradinaj mentioned by name certain potential witnesses and gave information regarding their place of residence and other personal details. This conduct amounts to a serious threat or other means of compulsion to induce another person from making a statement or to make a false statement or to otherwise fail to state true information to the Specialist Prosecutor's Office and or the Specialist Chambers. Second, there is a grounded suspicion that Mr. Gucati is criminally responsible for committing the offense of retaliation pursuant to Article 388 of the Kosovo Criminal Code. Specifically, there is a grounded suspicion that Mr. Gucati held 3 press conferences on 7, 16, and 22 September 2020, where he distributed or otherwise made available to the media confidential and non-public information and documents relating to the work of the Specialist Prosecutor's Office, including the names and personal details of potential witnesses, thus exposing these individuals to potential threats to their safety. This conduct amounts to a harmful act with the intent to retaliate for providing truthful information to the Special Investigative Task Force and or the Specialist Prosecutor's Office relating to the alleged commission of criminal offenses. Third, there is a grounded suspicion that Mr. Gucati is criminally responsible for committing the offense of violating the secrecy of proceedings pursuant to Article 392 of the Kosovo Criminal Code. Specifically, there is a grounded suspicion that Mr. Gucati held 3 press conferences on 7, 16, and 22 September 2020, where he distributed or otherwise made available to the media confidential and non-public information and documents relating to the work of the Specialist Prosecutor's Office, including the names and personal details of potential witnesses. Furthermore, there are articulable grounds to believe that Mr. Gucati's arrest is necessary because specific circumstances indicate that he is a flight risk, has the incentive, means, and opportunity to obstruct the process of criminal proceedings, and will repeat or attempt to repeat the criminal offenses. Thank you, Your Honor.
Thank you, Madam Court Officer. Mr. Gucati, I wish to remind you that is not the time to contest the reasons for your arrest today, but to acknowledge that you have been informed and you are aware of the reasons. You have the opportunity to challenge your arrest in writing with the assistance of your counsel and co-counsels. Mr. Gucati, can you please confirm that you have been informed of the reasons of your arrest?
I wasn't informed of the reasons of my arrest until the moment the ULEX police came to my office.
Thank you, Mr. Gucati. Do you wish to add anything on that? On the time you had to wait? Or if you want to add anything specific, you can.
Edhe njerë pyetje nëse ka mundësi se s'po kuptoj.
Could you ask the question again, please? I don't understand the question.
There is an issue with the interpretation. I asked you if there was anything you wanted to add to this, the fact that you were informed when the ULEX police arrived, and I think there's been a problem with the interpretation. If you can answer again, Mr. Gucati, and sorry for this.
Jo, unë s'kam çka të shtoj tjetër.
I have nothing to add to that.
And can you confirm that you had the opportunity to notify or have notified to a family member or another appropriate person of your arrest?
Jo, kanë mund të më njoftuar vetëm
I was informed myself, but they didn't need to arrest me. They could have invited me and I would have presented myself. They didn't need to bring the EULEX police to arrest me.
I understand what you're saying, but my question is, have you been able, when you were arrested, to inform a family member or another appropriate person?
An hour and a half later, I informed my son that I have been arrested.
Thank you, Mr. Gucati. Now let me inform you about your rights before this court. The law on the specialist chambers and the rules of procedure and evidence guarantee detained suspects a number of rights. I will read out the most important ones. First, you shall be presumed innocent until proven guilty beyond reasonable doubt. You are entitled to a fair and public hearing, subject to any measures ordered for the protection of victims and witnesses. You are entitled to challenge the lawfulness of your arrest and to request review of decisions on your detention and to appeal such decisions directly before the Court of Appeals. You have the right not to be detained for an unreasonable period prior to the opening of the case, and you have the right to be released if the specialist prosecutor does not submit an indictment against you at the latest within a year. you are entitled to a trial within reasonable time or to release pending trial if the relevant conditions are met. You have the right to have counsel assigned to you and without payment by you if you do not have sufficient means to pay for it. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsel of your own choosing. You have the right to have the free assistance of an interpreter if you cannot understand or speak the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt, and you have the right to remain silent, and no adverse inference shall be drawn from your silence. Mr. Gucati, you heard the most important rights that you enjoy as a detained suspect in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Yes, thank you.
I wish to inform you that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Therefore, representation by specialist counsel is mandatory. It is my duty as single judge to ensure that your right to counsel is respected. To this end, I have noted the Registrar's 18 September filing informing the panel of the appointment of counsel and co-counsel. I hereby inform you that you have the right to be represented by counsel appointed for the entire duration of the proceedings. If, at any point, you do not have sufficient means to pay for your counsel, you may apply to be declared indigent, and in such a case, you have the right to have counsel assigned to you. At this point, I would like to invite the specialist prosecutor to give any indication on the next procedural steps, in particular when he intends to issue an indictment against Mr. Gucati. Certain submissions on this topic were made during the first appearance of Mr. Haradinaj on Thursday, but the second suspect in the case, Mr. Gucati, was not present. I'm aware that there might be not a clear timeline at this point, but I would like to remind the prosecutor that there are two suspects currently in detention, and I expect the judicial process to be fair and expeditious. Madam Prosecutor.
Thank you, Your Honor. As already highlighted in a previous hearing held on this case on the 29th of September, the expeditiousness of these proceedings are an absolute priority for the Specialist Prosecutor's Office. At the same time, the completeness of the evidentiary material to be submitted in support of the indictment are a no less priority for our office, in the interest of all parties to the proceedings, primarily the suspects, but also the potential victims in this case, and in the interest of the court as well, of course. I note that the criminal offenses for which a grounded suspicion has been found date at least up to the 22nd of September 2020, which is only about 1 week ago. As previously highlighted, there are a number of indispensable investigative steps that our office is undertaking, including collection of information from witnesses who have felt intimidated, the transcription and translation of the relevant audiovisual material, the request of records from third parties, as well as the analysis of seized materials, including computers, telephone, and other items. In view of all these investigative steps and confirming that we are committed to ensure a speedy and efficient process, I can confirm that our office intends to file an indictment in this case within a 30 days time period. Thank you.
Thank you very much, Madam Prosecutor. I just note for the record that I mentioned a filing of 28 September by the Registrar. It's by the Registry. I would like to ask the parties now if they have any urgent issues that they would like to raise, which cannot be addressed through written submissions. I remind the parties that they need to give prior notice if any submission requires the disclosure of confidential information, so that appropriate measures can be taken. Mr. Rees, you have the floor, and I just want to mention I've received your 4 filings dated, I think, 28, 29, and 30, or 29, 30th, and 1st October. So no need to come back to all of them in detail, but if you want to add something, of course, you can. Please, Consul.
Well, as Your Honour has acknowledged, Mr. Gucati has already challenged in writing both the lawfulness of the arrest and transfer and the factual matters that are raised within the warrant. Your Honour has directed a response from the SPO in relation to the matters that are set out in the written submissions on those points. And I take it from that Your Honour is not in a position to deal with those matters as they are raised today in argument. There is one matter that I do wish to raise orally, and that is the issue of bail. Because whilst the SPO have been given time to respond to the challenge in writing to both the lawfulness of the warrant and the factual matters that are referred to therein, Mr. Gucati is currently in detention and will remain in detention while he awaits the SPO's consideration of these matters, and then thereafter the opportunity of the court to consider both the written submissions made on behalf of Mr. Gucati by myself and co-counsel Mr. Hysni, and indeed the submissions by the SPO. So I do intend to ask Your Honour to consider granting bail in the interim. There is a submission which I have put in writing which raises the matter of bail. It is my submission that notwithstanding and without prejudice to the challenge that we raised to the lawfulness of the arrest and detention in the first instance, that it must only be right for this court to, in those circumstances where there is a challenge outstanding, to be able to consider granting bail whilst those matters are being decided. After all, in Article 41(2) of the law, there is a right for a speedy determination of matters relating to detention. So I do ask Your Honour to consider granting bail whilst these matters are being determined. I note, without accepting, but note that the arrest warrant finds that there are articulable grounds to believe a risk of flight, of obstructing the progress of criminal proceedings, and the risk of further offences being committed in relation to Mr. Gucati. Again, without prejudice to my submission that the arrest itself was unlawful, and without accepting the factual matters that are alleged in the arrest warrant, it is my submission that any such risk that exists in relation to those 3 matters can be met in Mr. Gucati's case by bail together with a package of conditions that are designed to meet those risks. And if the court agrees that those risks are met by the conditions proposed, that in those circumstances, Article 41(6) of the law would no longer apply to justify detention, because there would be no longer articulable grounds to believe in the 3 risks that are identified therein. Just to give Your Honour some further background, Mr. Gucati is a man, a family man who is a father of some 7 children. They all live in the Scanderai area, the area where he is from. He has deep family ties to that area. His children are aged between 23 and 34 years. He has 8 grandchildren also, who again live in the Skanderai area. His whole family is based where he lives. The youngest of his grandchildren, some 4.5 months. The oldest, some 9 years. He is not a man of good health. He suffers from diabetes type 2. He takes insulin, and he suffers from high blood pressure. He also has a problem with his with mobility, quite a serious problem, which he was due today to have addressed with a planned appointment in the hospital in Pristina, with a view to moving towards an operation in due course to help him with that mobility problems. He suffers from asthma also, and as Your Honour has already heard, he works and has worked for 13.5 years as a secretary with the local primary school in Skanderai. He has deep family and community ties to that area. It's in those circumstances where, in my submission, bail could properly be granted on the following conditions that are proposed in the written submission, so both Your Honour and the SPO have had advance notice of them. It's proposed a surety in the sum of €5,000, surrender of his passport, a requirement that he lives and sleeps each night at his home address, daily reporting, if necessary, to ULEX police headquarters. Each of those 4 conditions, together with the fact that he has deep family ties, his whole family, children and grandchildren, based in the Skanderai area where he lives, all, in my respectful submission, can meet the concern of a risk of flight. We've also proposed in the written submission on bail that the court could consider a condition not to contact directly or indirectly any person the court thinks it appropriate to restrict contact with. Mr. Gucati is determined that he will abide by any conditions that Your Honour grants, while his challenge to the lawfulness of his arrest or detention is being considered. And we've also proposed a condition that Mr. Gucati does not go within 100 metres of the offices of the Kosovo Liberation Army War Veterans Association. Your Honour, of course, has heard from Mr. Gucati as to his role there, but he understands that whilst his challenge to the lawfulness of his arrest and detention is outstanding, and there is an issue over the factual matters contained in that warrant, that it's proper for the court to consider restricting his role, his active role, while those matters are being considered, and he would abide by any such condition. It's my submission that bail granted on those conditions would properly meet any concerns that otherwise arise out of 41(6)(b), the risk of flight, obstructing the progress of proceedings or committing further offences, particularly bearing in mind Mr. Gucati's background, the fact that he was cooperative on arrest, the fact that he has not been charged with any offence, and he may never be, the fact that the offences under investigation do not appear from the warrant itself to involve allegations of force being used, that the offences under investigation, according to the warrant, do not appear to involve allegations of actual threats being uttered, and that the offences under investigation do not appear to involve allegations of actual harm being caused, again, from the content of the warrant. It would also, in my respectful submission, be proportionate, proper to consider bail pending the resolution of his challenge to the lawfulness of his arrest and detention, in light of the fact that the offences for which he is being investigated are not substantive offences which fall under the jurisdiction of this court, but are offences relating to the administration of the system, which derive out of the Kosovo Criminal Procedure Code, and carry maximum terms of 1 year's imprisonment in one case, 3 in the case of the offence of retaliation. And although the maximum custodial sentence for the offence of intimidation is a higher figure, up to 10 years, there is a range of 2 to 10. And in circumstances where, as alleged in the warrant, that is, the offences do not appear to involve allegations of actual threat or force or actual harm being caused. Obviously, the higher end of the range for the offence of intimidation must always be reserved for those cases that do, by contrast, involve force and actual threat. So it is my submission that it is entirely proper for the court to consider, and indeed would be right for the court to grant bail, with or without the conditions that we have proposed, pending the challenge to his, that he raises to the lawful or otherwise arrest and detention. Unless I can assist any further, Your Honour.
Thank you very much, Counsel. Madam Prosecutor, do you have anything to say about this?
Yes, thank you, Your Honor. While the prosecution office will certainly reply in writing, as instructed by Your Honor, there are a couple of matters that I would like to address in response to counsel. The detention of Mr. Gucati remains absolutely necessary at this stage, considering that no new circumstances arise which could in any way adversely impact the findings underlying the arrest warrants. Not only the same circumstances that were highlighted in the arrest warrant remain in place, but new additional factual elements are to be taken into consideration in relation to the detention matter. First of all, since the issuance of the arrest warrant, Mr. Gucati has been notified of the criminal offences he's been investigated for and of the sanctions attached therein. These circumstances provide additional motives for Mr. Gucati to evade justice. But above all, in a number of previous public statements, Mr. Gucati has publicly affirmed that he would continue disclosing any materials pertaining to official proceedings of this court. He stated that on a number of occasions, and he undertook action after this statement in line with the announced intention that he made public. Mr. Gucati made such statements up to the date of the arrest, and the repetition of a pattern of criminal conduct that has been founded as grounded, at least in terms of grounded suspicion in the arrest warrant, has been only interrupted because of the arrest. Is the Specialist Prosecution's Office position that if released, Mr. Gucati would continue on this pattern of behavior, also considering that he would be able to rely on a network of support. And in relation to that, I would like to refer to the fact that today has been made public that the organization over which Mr. Gucati presides has been ordered not to disclose non-public or confidential materials pertaining to these proceedings. In relation to all of these considerations, and reserving any further arguments for the written submission, our office observes that the conditions set forth by the defense counsel for Mr. Gucati are totally inadequate to address the risks highlighted in Article 41(6) of the law. Thank you.
Thank you very much, Madam Prosecutor.
Can I reply
Counsel.
very shortly, Your Honour?
Very shortly, then.
Very shortly, very shortly. There is a change of circumstances since the arrest warrant was granted, and that is we have proposed what we say is a comprehensive package of conditions which Your Honour can apply and be satisfied that they meet the concerns that otherwise might have arisen under 41(6)(b). Although I add the caveat that we do not accept that, I am approaching the matter on the basis now that there will be a challenge to the warrant in due course to be considered, but we are addressing you now for bail in the interim period. Your Honour will also know that there was a request for disclosure of the evidence upon which the warrant was based, so that submissions could be made upon it. That request to the Specialist Prosecutor's Office was refused, point blank. And I am grateful for Your Honour's indication at the start of this hearing that Your Honour has in fact granted the application for disclosure that we were forced to make to the court because the Specialist Prosecutor's Office refused itself to make disclosure of such evidence that would allow us to make representations on the evidence today. So I don't make representations on the evidence. I seek to address the concerns that were in the warrant by reference to the conditions that I propose. I note that contrary to Your Honour's position set out very clearly at the start of the hearing that there would be no discussion of the evidence, the SPO in their response have taken the approach of not only referring to the evidence they had previously but have refused to disclose to us, but indeed refer to a moving feast. I ask Your Honour to consider the matter as I have put it, namely, I accept for these purposes that we have a challenge outstanding to the lawfulness of the warrant and the content of the matters therein. But given that challenge has been adjourned, and I understand why Your Honour's done that, inviting submissions in writing from the SPO, to look to see whether conditions and bail can be imposed to deal with the concerns that were otherwise in the warrant, not in terms of the factual matter or grounded suspicion, but in terms of the risk of flight, of further offences and of obstructing the progress of criminal proceedings. And it's my submission that it's entirely proper and proportionate, given Mr. Gucati's background, given the matters that are under investigation, the nature of those, and in contrast to other offences which come before the jurisdiction of this court, together with what is quite a stringent package of conditions that we have proposed. Thank you.
Thank you, Counsel.
May
Madam
I, Your
President,
Honour?
very briefly, please. Then.
Yes, a very short reply. Not on the merits of the request on bail, which was addressed earlier in my intervention, but in relation to the disclosure from the prosecution of materials of these proceedings. The defense has requested material in support of the indictment and has been informed that at the moment there are no materials in support of the indictment. He later requested further supporting materials and has been informed that they would be disclosed in the framework of the legal proceedings and not outside the legal proceedings via email as requested by the Council. In relation to that, I wish to highlight that already today the Specialist Prosecutor's Office filed a public redacted version of the SPO's request for an arrest warrant and a confidential redacted version for the benefit of the defense, and that pursuant to the single judge order of 30th of September, the SPO will continue to submit all materials as instructed by the single judge. Thank you.
Thank you, Madam Prosecutor. The matter will be dealt with very expeditiously. Now, I would like to ask Mr. Gucati if you have any issues to raise in relation to your arrest, transfer, or detention. And there is a further question that I would like to ask you. I've heard your counsel call your name Gucati. I just want to make sure that I pronounce it correctly. So if you can please tell me how it has to be pronounced as well, so we all follow the exact pronunciation.
So my last name is Gucati. So I have nothing to add to what was said by my counsel. So the arrest from Pristina and also the transfer from Pristina to The Hague has been very good, and I really wish to thank the security team. So as was already highlighted by my counsel, I have many health issues, and I have to say that these health issues have been taken into account by the people, by the personnel that have accompanied me, and I really wish to thank the detention facility personnel for all the support that they have given to me. So I'm not going to enter into the details to what the Council has already highlighted so far. I stick to what he has said thus far, and this is the end of my intervention. Thank you.
Thank you very much, Mr. Gucati. Am I pronouncing it correctly? I hope.
Falenderer behovet.
Thank you very much indeed.
Thank you. Mr. Gucati, I would like to tell you that pursuant to Article 41 and Rule 57, I shall review your detention at least every 2 months upon your counsel's or the prosecutor's request, or at my own initiative. Take it into consideration the type of offensives and mindful of Rule 57.1, I also invite the prosecutor to stick to the timeline that you mentioned regarding the indictment. This concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.